Welcome back. We'll start now with our next panel on criminal procedure. And this panel will be moderated by Dean Marc Miller from here at Arizona Law. And I'm just going to follow Chief Justice Rehnquist's lead in not giving a big introduction, so that's it. Dean Marc Miller.
Thank you, Sally. I've enjoyed the day so far greatly, and I'm hoping we can I know the panel will. I'm hoping as moderator I can help continue the high level of conversation. I had a special sort of point of privilege and pleasure in the first panel because it was moderated by my first non-judicial boss. I worked at the Office of Legal Counsel in the mid-1980s, and while Chuck Cooper was not the head at the point I came in, something he may have regretted the opportunity to veto. But in any case, he soon became head of that office, and I learned an enormous amount from him and from the others in that office. If you look back at the people that Chuck drew, those who were the deputies, the team he had, and put me to the side, it is a group of folks who have distinguished themselves in the bench, in practice, and in the academy. And so it's just interesting to see how we learn and how groups evolve over time. Among other things, Justice Rehnquist would come over occasionally for lunch with that group, and this is 10 lawyers sitting around the table talking, and that was one of the many extraordinary pleasures of being in that office. We've been very happy here at Arizona that Chuck has had very good reason to return regularly to Tucson, and so we get to see him beyond just the work in the center, and we appreciate that. In terms of the Rehnquist Center, it is a very important part of professional engagement and intellectual life of the law school. Sally has been a great leader for that center, and we are both thrilled that Andy Cohn has now joined the faculty and will help to nurture the range of activities, including conferences, judicial education, and judicial visits that the center has engaged in. Sally's title is not just Associate Dean, but also Chief of Staff. That actually means something at the law school. One of the current conversations among law school deans is whether or not the increasing complexity of American legal education, of the enterprise, requires a senior person with gifts in administration. And when that conversation came up, when I was appointed as dean at a new dean's conference, I said, oh, we do that. And people said, yes, but you have a person who really knows administration. And I said, well, let me tell you about her bio. And there were smiles in the room, and I don't know who has tried to copy since. Among the many lessons that Sally provides for me are comparisons, I'm afraid, to how Justice Rehnquist ran his chambers. And it is not uncommon, sometimes after, but often before a meeting, for her to remind me, she said, I never felt like Justice Rehnquist wasted 1 minute of my time. We have a wonderful panel here to talk about criminal procedure and criminal law. We'll actually, I think panelists might not want to draw any firm line between those two. And I see my job as moderator here, even though that is the field in which I do much of my work and teaching, largely to stay out of the way. I will follow the habit of very brief introductions, and we will go from there. Judge John M. Walker serves on the United States Court of Appeals for the Second Circuit, and before that on the District Court. Among the striking things about Judge Walker, like other judges who are here today and others on the bench, but not all, both his career reflects an immense variety of experience in the executive branch of government, as well as in the judiciary and in private practice, and also a deep commitment to legal education. And it's the breadth of involvement and experience over time is really quite striking. Alexandra Natapoff is the Associate Dean for Research and a Professor of Law, and Theodore A. Brunsma Fellow at Loyola in Los Angeles. She's an enormously productive scholar, well known in criminal law and procedure circles, but like what I think of as a very new era kind of professor, which is true of a number of my colleagues here at Arizona. She not only does everything that great professors did in the past, brilliant teaching, books, articles, powerful articles, well placed, but also a very high level of engagement with the media and the public. She writes both theoretical pieces and frames her work in ways that have regularly captured public attention. She did some very striking work, including a book on snitching, and more recently has been working on a range of legal issues coming out of both misdemeanor law that is largely left off of the academic radar and fundamental issues of representation and sort of some of the deeper theoretical puzzles of what it means to provide counsel. Our third speaker is Rich Friedman, who is the Aline and Alan F. Smith Professor of Law, and he is also a new professor. In his case, distinguished books, distinguished articles, but also runs a blog that is highly followed and is one of the handful of academics, many engage in blogs, but who has used that platform to engage both scholars and lawyers and the public in his area of expertise. And as we will talk about during the panel, it's a very active area indeed. With that, although there are only 3 panelists, we'll actually have 4 presentations. Again, it's not me. We're going to start with Judge Walker offering some brief reflections, continuing from the prior conversation on working with Justice Rehnquist. And then we will hear from Professor Natapoff, Professor Friedman, then come back to Judge Walker.
Well, I will be very brief because some of what I was going to comment on has already been commented on, so there's no need to repeat that. But I just want to thank Sally and thank the Rehnquist Center. Thank Dean Miller as well for inviting me and for hosting this conference, which I think is a tribute, well-deserved tribute to a remarkable Chief Justice. I'd like to say a few things about the Chief as a person, and my familiarity with the Chief, like Carolyn's, was basically through the Executive Committee of the Judicial Conference, which he chaired. He was an extraordinary public servant. I just can't emphasize that enough. He once remarked publicly that the judiciary, the federal judiciary, was the crown jewel in our system of government. And his dedication to the judicial branch and to the court was, to me, as absolute as it was inspiring. He spent 33 years on the Supreme Court, which is longer than all but 6 of the justices who preceded him. And when he was very ill with thyroid cancer at the last year of his life, he still wanted to serve. And during his final term, there was no let-up as he continued to write opinions and actively manage the administrative operations of the court. And no one can forget, I think, his courage and determination during his final illness when he administered the presidential oath of office at President Bush's second inauguration. In fact, his fellow justices have cited his determination and motivation for carrying on despite their own illnesses. He was also, as has been noted, calm and focused on the task at hand, and you've heard a couple of versions of what happened on 9/11. I was there as well at the Judicial Conference. This is sort of like a Rashomon experience. Each of us is describing a little different parts of that. But I do remember that the marshals brought in the first note saying a plane had had crashed into the World Trade Center in New York, but without any description of what the plane was or anything. And he just looked at it and said, you know, a little bit of news. Senator Biden, would you continue? The senator was talking at that time. Would you continue addressing the conference? And so that went on a little bit. And then the second note came in, and there was a second plane that had hit in New York, and he announced that. And then I think he turned to John Conyers and said, would you continue on? Because that was all in New York. We had an agenda to accomplish here. And it was important to do that. I mean, we were all sort of wondering now, maybe this was more than just coincidence, that these planes are hitting. But we didn't know much. But then the marshals did come in and handed him a note. And then at that point he said, okay, we're adjourning, but as Sally pointed out, we'll reconvene at 9 o'clock tomorrow morning, which obviously did not happen. He did send around a memo briefly that we were going to have there was some talk of another meeting later on that month in October, but it was decided that ultimately the business could be handled by mail or by email and votes without having to assemble until the spring. In a rare 2004 interview, Charlie Rose once asked the chief how he would like to be remembered, and the chief said, as a good administrator. And he pointed out in that interview that he liked to run, as he put it, a relatively smooth functioning court. It was an understatement, which is typical of the chief. But as I understand it, and of course the law clerks could really comment on this perhaps better than I could, the long conference during which the justices would review the petitions for cert had accumulated, they used to be long, but they had gotten shorter and shorter under the chief until basically it could be handled in a single day. In contrast, according to Linda Greenhouse, under Chief Justice Berger, the long conference began on the last Monday in September and concluded on the Friday before the first Monday in October. Went on for an entire week. Justice Ginsburg once put it succinctly. She said he kept the justices in line and on time. And she also commented in her remarks in memoriam for the chief that he was the best boss that she ever had. He was fair across the board to all of his colleagues, and he gave them all an equal opportunity, as has been pointed out, to speak. But I'm also understand, and maybe some of the clerks could comment on this, he was also extremely fair in assigning opinions. No doubt he would, when there was a controversial opinion and it was going to be a 5-4 split, he didn't want to lose that swing vote, so maybe he would assign the opinion to that person, but he would balance it out with others as necessary. What I wanted to say also, though, was that the Chief Justice was just a thorough pleasure to be around. You've heard about his sing-alongs, but also he would poke fun at himself. And I recall one lunch conversation at the Judicial Conference in which he was at our table, and he delighted in telling the story about how he sat by designation as a trial judge in Virginia in a criminal case, only to be reversed by the Fourth Circuit. This was within I think his first year on the court. Like so many who loved and admired the chief, I ached at his last year of suffering and felt his loss deeply. I've only read about his predecessors. I didn't know them. But I'm convinced that this Chief Justice Rehnquist, unpretentious, wise, and supremely intelligent, was as great as any of them.
Thank you. I want to echo everyone's thanks. Thank you to Marc and Andy for inviting me, to Bernadette and Emily for all their hard work. I'd like to start by appreciating what it means to have a panel on criminal procedure hosted by a center devoted to the constitutional structures of governance. It is inherently a profound recognition of the role, the governance role that criminal procedure plays, that it's not only a way, although it is importantly a way of regulating trials and the collection and use of evidence, but that in many ways it is part of the fingerprint of our democracy. And having a panel on it has been a wonderful moment to reflect on that function that it plays. Of course, it is such an important governance structure because the criminal system itself is such an immense part of the way that we govern. And when I say immense, I mean immense. The governmental functions alone of the criminal justice system, depending on who you ask, $260 billion industry, it employs millions of people. Of course, at any given time, it supervises and or incarcerates approximately 7 million people. Something that we don't often think about, the criminal system is iterative, right? So approximately 1/3 of the American adult population has been marked by the criminal system in some way with a criminal record. And of course, in any single year, there are on the order of 31 million police-initiated state citizen encounters, for lack of a better word. Another 31 million of those encounters are initiated by the citizenry themselves. So all this is to say that this is a governance structure that we use very heavily. Not only do we use it heavily, but we use it in a particularly important way from a democratic perspective, because the rules of this system, of the criminal justice system, are particularly important for the politically least important among us, for the poor, for people of color, for people who live in low-income, high-crime communities. Unfortunately, for many of these citizens, the Establishment Clause or matters of separation of powers may seem like remote issues at times, but the operation of our criminal justice system and the constraints and authority that we vest in police are a matter of daily experience and occasionally survival. So in some ways, criminal procedure is a governance structure for the vulnerable. This is, of course, especially true with respect to the police function. And so I just want to spend a little bit of time here thinking about how the Rehnquist Court has shaped and formed and helped us understand the police function and what it means for us. We are, of course, at a particularly challenging and sensitive historical moment with respect to that question. The recent deaths of Michael Brown in Ferguson, Missouri, Eric Garner in New York, 12-year-old Tamir Rice, of course, have placed this issue on the front burner for many. And it raises this quintessential governance question of how should our democracy define and create and constrain the police power itself. The Rehnquist Court provided us with the most extensive elaboration, the greatest answer to that question. Of course, it inherited a long line of precedent from prior courts, but the Rehnquist Court really gave us many of the tools that we use to answer that question jurisprudentially. That jurisprudence, for those of you who haven't taken criminal procedure in a little while, is a jurisprudence of suspicion, in effect. Police acquire governance power to the extent that they have legitimate suspicion, evidence and inferences drawn from that evidence that amount to reasonable suspicion or probable cause that someone has done something criminal or poses a threat. And so while we can think of that question as an evidentiary question, right, weight of the evidence, we should also see it as a governance question, that the nature of that evidence, the nature of the inferences that we are permitted to draw from that evidence, in many ways define the line between the police power and the individual. And so it's an arena in which we work out a lot of these questions about how we think the police power should be defined through this lens of how we define suspicion and the evidence sufficient to constitute it. I'd like to open the question. Hopefully we'll have a chance to talk about it more in conversation, but just mentioning a few of the key contributions of the Rehnquist Court to this question, and then think a little bit about how it resonates with some of the issues that we're currently grappling with. So 3 seminal cases, Pringle, Wardlow, and Wren. I'll take them in reverse chronological order. Maryland versus Pringle, drugs in a car. If there are drugs in a passenger car, everyone in the car can be arrested, including a passenger to whom the car does not belong, even if the drugs are found in the back seat. Just classic probable cause case. Illinois versus Wardlow, the Headlong flight case, you may remember. This case holds that a person who flees the police in a high crime neighborhood, not any neighborhood, but in a high crime neighborhood, has thereby generated sufficient suspicion to trigger the police power to detain them, to stop them. And finally, Wren, one of the most famous of this trilogy, that emphasizes that not only is suspicion the most important foundation for the police power, it is the only one. That subjective motivations of the police, most famously racial but not limited to issues of race, that subjective motivations of the police do not affect the Fourth Amendment police power to stop or search or seize. Can we put a slide up? So I want to think about how these cases intersect with the testimony of perhaps the most famous police officer of the day at the moment. So this is the grand jury testimony of Officer Darren Wilson before the Ferguson, Missouri grand jury. And this is not the segment of his testimony that has been most focused on. It doesn't go to the question that was substantially at issue in that case, but I think it's illuminating for our purposes. Officer Wilson is asked, did you have a volatile relationship with the community? He says it's an anti-police area for sure. Tell me more. He talks about the gangs, the violence, the gun activity, the crimes. Question, you were on pretty high alert at that point, knowing the vicinity? He said, yes, that's not an area where you can take anything really lightly. Like I said, it's a hostile environment. There are good people over there, there really are, but I mean, there's an influx of gang activity in that area. So I want to suggest that Officer Wilson's understanding of his role is largely consonant with the Rehnquist court's understanding of the police power. So he says it's an anti-police area. He notes that he was on high alert. This is not an area where you can take anything lightly. And this is essentially the spirit of Wardlow, that neighborhood matters to the it matters so much that the character of the neighborhood actually can change the police function. It can expand the police's power to stop people. It can change the inferences that police are permitted to draw from events, thereby expanding the evidence that they have at their disposal on which they're permitted to act. And it subjects everybody in that community to that heightened scrutiny. He says, there are good people over there, but. In a way, this is Pringle, right? The drugs in the car case. We know there might be innocent people in the car. We know there are good people in the neighborhood. But the presence of drugs or the presence of gangs or the presence of crime is sufficient to cast sufficient suspicion on everyone in the car in the neighborhood to expand the police authority to engage everyone in that neighborhood, in that car, or in that vicinity. And lastly, with respect to race itself, so as you probably know, the recent events have generated a great deal of democratic activity and protest. Hundreds of thousands of people have marched in the street. Congressional staffers have walked out in protest over the events in Ferguson and New York. And this reaction, of course, is not only because people think that perhaps Officer Wilson or the other officers involved in these incidents were themselves racist, but the concern is that the criminal system itself, the grand jury process, the indictment process, the follow-up process, is not responding to that possibility. And that's Wren. Wren holds that the core of the police officer's job is to act on suspicion, and that we have other constitutional tools, the equal protection tools, in effect tools extraneous to the criminal justice system itself, to handle impermissible racial motivations, but that at its core, the police function is about suspicion and evidence, and the fact that it might be motivated by or shaped by race does not, for the purposes of the police power, actually matter. So there are lots of, I think there's a lot of food for thought in thinking about these confluences, and I just want to suggest two to end. One is that it reminds us that criminal procedure doctrine is not an abstraction, right? It's not some legal theory. It is intimately connected to the way that actual police officers conceptualize their actual power and their actual role, and thereby their actual governance function. And two, I think it reminds us, to pick up a thread of the theme that we've been engaging with all day, the profound importance of localism. Of course, we don't have a criminal justice system at all. We have dozens of them. And as we heard this morning, the police power is a function that's reposed in the state. It may indeed be one of the quintessential such powers. And therefore, it's an arena in which the state has the freedom to get it wrong. I think that the Rehnquist Court's jurisprudence can be interpreted as an invitation. It opens the door to local judgments about people, about neighborhoods, about groups, and the inferences that are to be drawn from those things. And that local landscape today is changing. Many states are experimenting with new variations on the exclusionary rule, with community policing, with body cameras. And I think that what we will see is that in response to the democratic debate currently going on about policing, that we will see more and more states, cities, police departments, even individual police officers, essentially taking the Rehnquist Court's invitation up and engaging in more experimentation.
Good afternoon. I want to echo the thanks that everybody's offered to the Rehnquist Center for putting on this wonderful conference and for inviting me. And coming from the town now known as Ann Arbor, I want to express a particular thanks for scheduling the conference in February. So when I was invited, I asked Andy Cohn if I could speak on the Confrontation Clause, and because much of my work over the last couple of decades has been focused on that. And he said something to the effect of, do you really think anybody would be interested in hearing you on anything else? So the Confrontation Clause, it is. So there's a great transformation during the years of the Rehnquist Court, culminating in the case of Crawford v. Washington, which I regard as a tremendous accomplishment, one of the really heartening developments in constitutional law in the last several decades, whatever has happened to it since. I think it represents a different way of thinking about this particular right, and really a different approach to the Constitution. And it's one the Chief Justice didn't like at all. So the Confrontation Clause guarantees the right of a criminal defendant to be confronted with the witnesses against him. Simple, straightforward prose, but what does it mean? And it's been clear for decades. The clause was first made applicable to the states in 1965, and that's when it really took on life. It's been clear it means that some hearsay, some out-of-court statements can't be presented against an accused, but it doesn't prevent all hearsay. So what is the approach? And the Supreme Court had a great deal of difficulty with this, beginning with a case called Ohio v. Roberts in 1980. It adopted a view that the clause really was meant only to exclude unreliable evidence. In some cases, that would be a case-by-case determination, but reliability could be determined on the basis of prevailing hearsay law. If a statement fell within a firmly rooted hearsay exception, it could be admitted. Well, what's wrong with that? It was murky, it was very uncertain, but lots of constitutional law is. It lacked any historical basis, it lacked any textual basis. I don't think it, worse than that, I don't think it articulated any principle worthy of respect. Those of you who remember with horror studying hearsay law in law school might have thought it's all a jumble. I think it is. And the idea that this is constitutionalized, you wonder, what's that all about? And worse yet, I think, it didn't provide any protection, or at best uncertain protection, in cases where historically and just as a matter of basic understanding of what it means to be confronting the witnesses against one, you'd think that the right would clearly apply. So one case I'll give from 1986, Lee v. Illinois. There's a really nasty murder of an old woman, and one of the alleged conspirators told the police that he and Lee, his girlfriend, had done it, and the statement was he took on a great deal of blame himself, Thomas, the speaker. Now, since 1662, there's the case of Thomas Tong, in which the judges of the King's Bench said, look, if somebody makes a confession, that confession can be admitted against the confessor himself, but it can't be admitted against somebody else if the confessor doesn't testify at trial. That was a very simple, basic proposition. But in 1986, under the Ohio v. Roberts regime, this was a very difficult case. And it was like, is that statement reliable? The court held 5-4. It was admissible with the Chief Justice in the dissent. Now, if you ask, is it reliable? Gee, guy goes into the police and says, I committed murder and I had a large role in it. It might be pretty reliable. But there's something missing there, which is that he's effectively testifying in the police station house against somebody else who doesn't have a right to confront him, be confronted by him ask questions face to face. A few other cases. Bourgeois, United States versus Bourgeois in the United States, by the Chief Justice, said with statements by a conspirator during the course of and in furtherance of the conspiracy. The statement in Lee, it wasn't during the course of the conspiracy because it was blowing the conspiracy apart. But with respect to a statement made by a conspirator during the course of the conspiracy, no independent demonstration of reliability is necessary. And he basically, the Chief Justice said, and he was right about this, well, it's a firmly rooted hearsay exception for statements by conspirators. Well, okay, fair enough, it's a firmly rooted hearsay exception, but how does that fit in with a theory of reliability? Are we really going to say that statements by conspirators during the course of a conspiracy, pursuing the conspiracy, are reliable? I mean, that really makes very little sense at all. What they are is statements doing the day's business, the day's dirty business, the conspiracy business, but they're not reliable. What they aren't also is they, unlike the statement in Lee, really don't constitute a person acting as a witness against the defendant. It's just going about the day's business. So a case like this, I think, created dissatisfaction, and there's some attempts to rethink the clause. In the case of White v. Illinois, in 1992, the Justice Department, I think it was a brief written by Samuel Alito, or at least it was based on an earlier brief by Alito. The government said, let's rethink this, and they wanted to narrow the scope of the clause to formal testimonial statements. And the Chief Justice in that case said, nothing doing, it's too late in the day to rethink this. The court was committed to the Ohio v. Roberts line. But Justice Thomas did write a brief concurrence adopting that view. That was the first crack, I think. Then in 1999, a bigger crack, perhaps. Another conspiracy case, Lilly v. Virginia. Murder of the 3 guys went on a drunken spree in the course of which a poor young man was murdered. And Marc Lilly tells the police that brother Ben, his brother, had been the trigger man. And again, under the old principles, this shouldn't be admissible against Ben Lilly. Marc doesn't testify, but and everybody kind of got there, but they couldn't quite figure out what the rationale was, and there was a lot of kind of carving up and trying to figure out how you carve up the exception, the hearsay exception for declarations against interest. And so the Chief Justice agreed that it shouldn't be admitted, but he felt that the court went overboard in saying that accomplished confessions could never be admitted. Justice Thomas adhered to the view of only formalized testimonial material, and he stayed with that view for the remaining 15 years. Justice Scalia wrote a brief concurrence, which in retrospect was real foreshadowing. Basically said, this is a confession. This is a paradigmatic confrontation violation. Come on, what are we talking about? And Justice Breyer wrote another concurrence, which particularly pleased me. I, with the late Margaret Berger, had written a brief for the ACLU saying, you know, the confrontation clause that's been applied is a disaster. It really ought to be narrowed. It doesn't apply to all hearsay, but only certain types of statements. We're a little bit indefinite about just what that was, but that within those limited bounds, there should be a categorical exclusion. And I was just reminded, we had a sentence in our draft saying the key to understanding the confrontation clause is to understand its narrow focus. I was very pleased with that sentence, but I did a dumb thing. I opened up my mouth to the legal director of the ACLU. I said, this is going to be the first time in history that the ACLU will submit a brief to the Supreme Court arguing for the narrowing of a constitutional right. And that made him nervous. So we changed it from the key to understand is the narrow focus to something like the key is to understand its special function. But the idea was basically the same, that this is a right that needs hard lines. It needs categories. Instead of just balancing from case to case, it needs definable limits, but within those limits, it should be, we call the categorical. I don't mind the word absolute. Anyway, Justice Breyer wrote an opinion saying, pointing to the brief and saying, we don't have to decide that now, but sometime soon we may. And sometime came 5 years later. But first, I want to mention one other case, which is still of very live interest, Maryland v. Craig. The cases I've been talking about have all involved out-of-court statements, and the question is, can that be admitted? Maryland v. Craig involved a different part of the problem. It was a young child who was allowed to testify under Maryland procedure from another room with electronic hookup, a one-way video into the courtroom. So she was in the room only with the prosecutor and the defense attorney. And the court 5-4 held that this was okay. The chief was in the majority, an opinion written by Justice O'Connor, and it was a very balancing type of opinion, speaking about significant governmental interests for which the confrontation clause must give way, and the right of what she called face-to-face confrontation is one that had to give way in this case. The defendant didn't get to be face-to-face with the witness. And Justice Scalia in the dissent was, let's say, upset, saying, what are you talking about, face-to-face confrontation? Another word for face-to-face confrontation is confrontation. He said you're just taking the confrontation out of the confrontation right. That's all it means. And he used the word categorical. The right ought to be a categorical one. Okay. So that again was foreshadowing. So I remember in 2003 getting an email message from a former student of mine, of ours, not of mine, named Jeff Fisher, who was then introduced himself by email as an attorney in Seattle. He said, here's a petition for certiorari in a confrontation clause case. So, well, I opened it up. Very interesting. The first part of it, I said, this is a very good professional petition. It raised a narrow issue in the case of involving a circuit split among the state Supreme Courts. I thought this was very good. The second part advocated adoption of a brand new approach to the confrontation clause, a testimonial approach, citing my work a good deal. And at that point, I said, this is a great petition. And sure enough, the Supreme Court granted cert. And we were nervous. I had a good feeling they'd grant cert, but the question was, would they grant cert on that broader issue, or would they only be interested in the narrow issue? And it was a simple cert grant. And I encouraged Jeff, and he did it. I said, put the broad issue up front. I didn't care about the narrow issue, I confess. Put the broad issue up front, because I think that's the only way it'll get attention. And he did. But until we went into the courtroom, I was second chair to him then. Until the arguments started, we had no idea really whether the justices would be at all involved, because what he was asking for was such a radical transformation of the law. But virtually the entire argument focused on whether the court should adopt the testimonial approach. And we had the feeling afterwards, we may get 7 votes, everybody but Rehnquist and O'Connor, who were the two sort of balancers. And that's the way it happened. So very briefly, what the approach says is, what is the confrontation clause about? It's about witnessing. This will be my rendition of it, but the idea is that if you're acting as a witness against an accused, you have to do it under the prescribed procedure, which is not, as it was in Crawford itself, speaking to the cops in the station house. It's not as it was in Hammond v. Indiana, which was a case I handled shortly into the administration of the tenure of Chief Justice Roberts. It's not by talking to the cops in your living room. It's by testifying at trial or some other formal proceeding under oath, subject to cross-examination, face-to-face with the accused. That is the way that testimony against an accused has been given in Anglo-American courts for over half a millennium, in other courts going back to Roman and biblical times for more than a couple of millennia. That's what the Confrontation Clause is about. It's not a rule of evidence. We say, in rules of evidence, we say, you know, a little bit better evidence, let it in, a little bit worse, don't. It's a fundamental procedure about how we run criminal trials, about how people who act as witnesses give their testimony, because that's what witnesses do, they give testimony, how they give their testimony against criminal defendants. So like other fundamental procedures, we don't say, well, in this case we don't really need a jury. In this case we don't really need to give the defendant right of counsel. We don't do that. We say, okay, however guilty we think you are, you have a right to a jury. However guilty you think we are, you have a right to counsel. However reliable we may or may not think this evidence is, you have a right to have the witness come to court and testify. So that's the basic idea. The Chief Justice, as I said, didn't like it at all. He didn't find support for this testimonial, non-testimonial distinction in historical materials. I think if you look at it as an evidentiary matter, he had a point, I mean, because it wasn't articulated that way. But I think that the history, in a broader sense, made very clear that not just in the framing generation, but for centuries before, it was a central pillar of the English style of trials, that witnesses testify face to face. It was a great point of pride of the English. So Crawford, it was in 2004, right near the end of his tenure. I'm happy to answer questions about what's happened since, because I'm not pleased with the way the doctrine has developed since. But I think that Crawford got it very basically right. I will just mention, coming up next month, March 2nd, there'll be, I think, the biggest case in this line since Crawford, Ohio v. Clark, involving a young child again. It's the first time the court has handled a confrontation case involving a young child since Crawford. And it was a little boy under 3½, not yet 3½, who came to preschool with welts on his eyes. And when asked what happened, he said D, and D was his mother's boyfriend. And so that became the basis of, he was not allowed to testify at trial, but his statement was admitted. So it's a very complex matter. For what it's worth, I've put in an amicus brief with a renowned developmental psychologist saying, and again, I'm adhering to this idea of categorical rules, but our view is that a child that young really shouldn't be considered a witness at all. I don't think a child that young has a concept of what it means to testify, to give evidence. It doesn't have a concept of the consequences of his likely statement. He's not a witness, but he was a source of evidence, and of potentially very probative evidence. So our view is that the defendant shouldn't have a right to cross-examination at trial, but should have a right to have the source of evidence as the child examined by an expert, by a qualified psychologist. So I have some fear that, as Lynn Baker said, that I will get the ultimate diss if nobody will pay any attention to this in the case. But that's for what it's worth. I got an audience here, so that's the way I would handle that problem. It seems to me it's better for truth finding. It's better for the accused has a better right than cross-examination of a young child, because that's a disaster and it's less traumatic for the child. So we'll see what happens in Ohio v. Clark. Thank you.
I was really happy when Sally asked me to participate on this panel. The chief and his court were prolific in the area of criminal procedure. I have some statistics for you, and they're quite amazing, to me anyway. According to the Supreme Court database, Justice Rehnquist, and then Chief Justice Rehnquist, he personally authored 190 opinions, including concurrences and dissents, in criminal procedure cases. And during his tenure as Chief Justice, the court itself published 538 opinions, including concurrences and dissents, related to criminal procedure, more than in any other area of law. One of the most striking aspects, I think, of the Chief's work in the criminal justice area was his practical understanding of how the criminal justice system played out on the street, not only for the accused, but also for the police and for the public. His pragmatism, I think, can be seen in part as to a degree influenced by what he may have perceived as a tipping in favor of defendants' rights under the Warrant Court, and the cases we all know. But there are cases, Gideon, Brady, Miranda, of course, which I'll talk more about, Mapp against Ohio, Escobedo. But it's not as though the chief rejected these cases. He respected them. But in his view, I think, it's fair to say that there was another side to it that could be emphasized in his jurisprudence. And he set about doing that, and I want to specifically talk about Miranda and the exclusionary rule. I think that the basic concept here is that the justice sought to restore the balance, the appropriate societal balance, between protecting the rights of defendants and ensuring an effective police force, and still ensuring effective police force, and maximizing public safety. So in Miranda, we're all familiar with it. You have the right to remain silent. Anything you say may be used in a court of law. You have a right to an attorney, and if you cannot afford one, one will be provided for you. These warnings must be given by the police, according to Miranda, as a prophylactic aimed at protecting against the possibility of coerced confessions, which was the time-honored problem, and one that was thought to be dealt with under the opponents of Miranda by rules against involuntary confessions, coerced confessions, and the like. The court of the Miranda court under Warren in 1966 felt that no, there had to be a prophylactic approach, and this was the approach that the FBI had taken, and those particular warnings were given by the FBI, and they seemed to be persuaded that that wasn't going to be a problem if those were given, that this would work. So early on, the chief, and then before that as Associate Justice, and before that even as Assistant Attorney General, was one of Miranda's most consistent skeptics. As Assistant Attorney General in the Nixon administration, he drafted a memo suggesting that the President appoint a commission to consider a constitutional amendment overruling Miranda. And as a justice, he authored opinions limiting the scope and rigidity of Miranda, including cases like Michigan against Tucker and Duckworth against Egan, which I'm going to mention in a moment. But ultimately, 34 years after Miranda was decided, when the court was given the opportunity, really, to do away with the rule in Miranda, in Dickerson, it was Justice Rehnquist who wrote the opinion that saved Miranda. And that is a very interesting case because it points out a lot of aspects of the way Justice Rehnquist thought about criminal justice and his pragmatic approach to dealing with these issues. So he took in Michigan against Tucker, just very briefly, I'll go through some of these cases. That was a case in which the police informed the subject of their Fifth and Sixth Amendment rights under Miranda, but didn't advise him that he had a right to have counsel appointed if he could not afford one. And that interrogation took place before Miranda, but the decision came. The case was tried after Miranda, and the question there was whether that disqualified the statement, the omission of the right to appointed counsel. Justice Rehnquist said it didn't, that the statement was admissible, and he said we must weigh the strong interest under any system of justice of making available to the trier a fact all concededly relevant and trustworthy evidence. In this particular case, we must also consider society's interest in the effective prosecution of criminals. So he was balancing there the individual rights and the public's interest in safety, as we've seen. In this case, of course, the police had acted lawfully, pre-Miranda. So there was nothing to deter by Miranda. That wasn't as though they had done anything wrong. And there was no question particularly about every indication was that the confession itself was not coerced or involuntary, and it was reliable. So the scale tipped in favor of admission. At that point, he said the exclusionary rule, which would keep the statement out, they're calculated to prevent and not to repair. It is not a right to a defendant doesn't have a right to an exclusionary rule. So the purpose is to deter, to compel respect for the constitutional guarantee by removing the incentive to disregard it, in his words. Now, a year later, in U.S. against Peltier, which was not a Miranda case, he held the Fourth Amendment's exclusionary rule would not apply retroactively to a case on direct appeal when the rule it overturned the prior rule limiting border searches was in Almeida Sanchez against United States had been decided, and that limited border searches because the agents had been too far away from the border. But then in Peltier, he said that wouldn't apply retroactively because there was no deterrence as well. And in Colorado against Connolly, he held that the government need only prove waiver of Miranda by a preponderance of the evidence rather than clear and convincing. And again, his language is helpful in this case. Exclusionary rules are very much aimed at deterring lawless conduct by police and prosecution, and it's very doubtful that escalating the prosecution's burden of proof that Miranda was waived in suppression hearings would be sufficiently productive in this respect to outweigh the public's interest in placing probative evidence before the juries for the purpose of arriving at truthful decisions about guilt or innocence. In Quarles, New York against Quarles, in 1984, that was another example of his real-world approach. So they caught a subject who they believed to be armed and dangerous in a supermarket. And the reports were that he was armed when he went in there. But when they found him, he wasn't armed. He didn't have the gun. So they then immediately asked him, "Where's the gun?" And he said that it was stashed somewhere, and they went and got it. And then they gave him his Miranda warnings. And so the question was his statement about the gun admissible? And Justice Rehnquist, again, said he rejected the arguments that because the warnings hadn't been given for that particular statement, that particular statement was inadmissible. He established a public safety exception to Miranda. He emphasized the fact that the police needed to find the loaded gun before an accomplice retrieved the gun or someone else happened upon it, and that was an immediate concern to the police. The deterrence goal would be misdirected if the evidence was excluded. We wouldn't want the police deterred from searching for the gun right away. And why should the choice between immediate recovery of the gun and giving Miranda warnings penalize the public? So the court, he basically held there that it should not be concerned solely with the defendant's rights. It had to balance these rights against the public's interest. And he felt that an exception for public safety was appropriate, and he convinced his colleagues to go along. So these various rules were designed to serve practical, functional purposes. And taken together, the exclusionary rule and Miranda serve to protect an individual's right against incrimination, to be sure, and also to ensure that the evidence presented to juries is trustworthy and not the result of coercion. These tenets, these two key underpinnings of Miranda itself are manifest in Duckworth against Egan, where he rejected the defendant's formalistic argument that the officers failed to advise him of his Fifth Amendment rights when they informed him that he had a right to remain silent and a right to counsel if and when he went to court, which of course is not part of the Miranda test. In fact, the officers were operating on practical experience because that's when counsel are normally appointed to represent a defendant. But they didn't get the language correct in terms of the Miranda warning. Chief Justice wrote that the Miranda warnings need not be given in the exact form described in the opinion, as long as they reasonably conveyed the suspect's rights. Or as his opinion put it, no talismanic incantation was required to satisfy its strictures. He was acutely sensitive to what needed to be accomplished and how to accomplish that goal. Once the gist of the rights were understood, the purposes were served, regardless of whether every word was perfect. Another reason I think Duckworth is interesting is that it highlights why the chiefs felt so strongly about the importance of limiting Miranda. He was concerned that a broad, inflexible Miranda doctrine, while serving to protect an individual's right against self-incrimination, could also provide a technical loophole through which defendants could escape prosecution and conviction. And he explained this later in what I think is his best-known Miranda opinion in Dickerson. In the body of that opinion, he pointed out that the disadvantage of the Miranda rule is that statements which may be by no means involuntary, made by a defendant who is aware of his rights, may nonetheless be excluded, and a guilty defendant go free as a result. So that quotation comes from Dickerson, which is the case I really wanted to get to, and what I've said now is sort of a prelude to all of that. But by way of background, in case, just to refresh everyone's recollection, way back when Miranda was decided in 1966, 2 years later, Congress enacted a statute that sought to overturn Miranda. And if Miranda wasn't a constitutional decision, it possibly could have been overturned by Congress, because if it was a statement by the court of a sort of supervisory nature, didn't have full constitutional content, then perhaps Congress could overturn it. And they passed this statute, which went back to the test, the voluntary test, and said nothing about warnings. So the interesting thing is there that despite the Chief's long-standing criticism of Miranda and its progeny, he not only concluded that Miranda was a constitutional decision and thus could not be overruled by congressional legislation, he assigned himself the opinion. Now, his determination that Miranda was a constitutional decision came under a withering dissent from Scalia, who said that, go back to the basic Constitution, the ills that the Fifth Amendment was designed to address, and what we're talking about here is not a constitutional underpinning for this particular decision, for the warnings, but rather a non-constitutional prophylactic set of rules that have no greater force than a statute would. But he ruled to the contrary, the Chief. And I think Dickerson is emblematic of his judicial pragmatism for several reasons. First, he recognized that Miranda had become, and I quote, embedded in routine police practice to the point where the warnings had become part of our national culture. And he concluded that to overrule Miranda would actually upset the administration of justice more than it would promote it. And later on, Chief Justice Roberts, reflecting on this decision, put it this way. The Chief appreciated that Miranda had become part of the law and that it would do more harm to uproot it, and he wrote that opinion as Chief for the good of the institution. And I'll come back to that in a minute. Second, with regard to Dickerson, the Chief believed that the totality of the circumstances test that was set forth in the statute, Section 3501, would be more difficult than Miranda for law enforcement officers to conform to and for courts to apply than Miranda itself. And that indicates that he never lost sight, he did not lose sight of the fact that the day-to-day task of administering the criminal justice system in the field falls to lay people. Third, I think it's important. I think it's important to observe that the Dickerson opinion reflected the impact that Justice Rehnquist himself and others on the court who had taken cases in the Miranda area had the impact. It reflected the impact that they had had in limiting Miranda, and he referred to that in his opinion. By 2000, the Rehnquist court had cabined Miranda's scope and manner of application such that the concern of its producing a technical loophole had been largely eliminated. And the Chief saw no real need to do away with Miranda, despite his contrary views as an Assistant Attorney General 3 decades earlier. Which brings me to the fourth point, which I alluded to briefly a moment ago, and this is something that Professor Schwartz mentioned on the first panel, that he was almost Holmesian in certain respects, and that was his overriding concern for the institutional stability of the Supreme Court. If Miranda were overturned, how would the court be perceived as an institution? And would it be seen as unstable, perhaps depending upon political outcomes in terms of who appointed the justices and the like? And I think there was a concern of his on that part. So I think that his impact on the Miranda doctrine and the exclusionary rule continues to be felt after his passing, after his death. And an example of this is in Herring against the United States, which is a 2009 decision written by Chief Justice Roberts. The court held there that the exclusionary rule did not require suppression of drugs on a warrant, based on a search and a warrant, where the clerk of the neighboring county had told the officers that the warrant was outstanding, but which, unknown to those officers, had been recalled. Chief Justice Roberts, I think reflecting to some degree the thinking of his former boss, wrote the majority opinion, explained it in words that could easily have been written by his former boss. To the extent that application of the exclusionary rule could provide some incremental deterrent, that possible benefit must be weighed against the substantial social costs. The principal cost of applying the rule is, of course, letting guilty and possibly dangerous defendants go free, something that offends basic concepts of the criminal justice system. Herring is a product, I think, of a clear-eyed assessment of the interests at stake in the criminal justice calculus, and also the careful, pragmatic weighing of those interests. But I think it's also an indicator of the permanence of Chief Justice Rehnquist's legacy. Thanks.
Rich, please. Yeah. Judge Walker used the term pragmatic several times. Of course, it's very important in describing Chief Justice Rehnquist in this area, and it reminded me that something I meant to say, that in the area I was talking about, and I think some others as well, you see a division between pragmatists and those who are willing to set apart lines on the basis of principle, and it's interesting to see how it's carried through. I think this also covers, say, the area of Apprendi, which on sentencing and what has to be done there. So, I'm sure this is an oversimplification in some ways, and I don't know if it would carry through to other areas. But in those two areas, in the Confrontation Clause and in Apprendi, you see on one side Scalia, Thomas, Ginsburg, Souter, and then Sotomayor, Stevens, and then Kagan. Those have been the kind of the principalists. And the pragmatists have been Rehnquist, now Roberts, Kennedy, O'Connor, now Alito, and Breyer. It's not the typical left-right split that we might think. I don't know to what extent it carries over to other areas, but in those two, it's been very sturdy.
I've got questions on that, but I'd love to take the time and reach out, and if there are questions from the audience to any of the panelists on any of the cases or topics, do that, and if not, I will. There's one. Great.
I have a question tangential to John Walker. After events in Ferguson and New York, my son, the younger son, first time in his life interested to become an activist, great surprise, and he wanted to initiate a jury reform. And we discussed this because whatever these laws, ultimately the jury will make decision. And today's jury, you know, through voir dire is leftover jury, basically not selected, but strike out and then the leftover jury. And I know the reason behind this, but what about the idea of having, let's say, 2-3 jury members selected by defense, 2-3 jury members selected by prosecutor, and then the leftover be there, and then we have jury members, because for 1 year I watched jury cases, and I found out that professionals get permission, doctor or lawyer and teachers, we end up with a certain demographic of jury members they don't have really much idea about the world around themselves, and they may be more susceptible to be influenced by good lawyers who talk very well, who are sophisticated, and basically they can be swayed easily. Therefore, if we have few jury members who have kind of strong opinions, what do you think? And I'm looking for a mentor for my son on this issue, in fact.
Well, I think these cases raise the question of grand juries. A grand jury process, the grand jury process brings the indictment and decides whether there should be an indictment or not based on probable cause. And in these various instances, grand juries decided not to. Grand juries are secret affairs, and they're not open to the public because they want to protect the rights of people who are, during an investigation, who are not found to have engaged in any wrongdoing. So they're handled differently than petty juries or trial juries. In the trial jury process in this country, the parties are involved in the selection, deeply involved in the selection. They get to strike jurors that they don't like, and subject to a rule based upon impermissible reasons such as race, that kind of thing. But they get to a certain amount of peremptory challenges. They could strike jurors, and also they can move to the court to have jurors removed for cause. So the problem that you're talking about doesn't exist with regard, I don't think, to trial juries. As far as grand juries are concerned, that has never been part of the process. They've just been kind of selected and put in there and given questions as to whether they can be fair and impartial, and then they proceed. But on the other hand, they're not actually deciding guilt or innocence. They're just deciding whether the indictment should be brought. Now, there is a dramatic impact, of course, when in a highly controversial case like this Ferguson case, and also the one in New York, the grand jury decides not to bring a true bill. But I'm not sure that tampering with that process and somehow getting a process of having various parties get involved in the selection would be worth it under those circumstances. Maybe I misunderstood.
I was talking about trial jurors.
Oh, trial
jury members.
Yeah.
Instead of to be striking out, to be selected, few of them, so that we have some people with certain opinion or life experience stir up the jury, because otherwise I see jury members, because I served in jury, I experienced myself too, they become susceptible to be duped by the sophistry of one of the parties.
Well, the selection process, first of all, in our system, it's the flip side of that. We exclude jurors, we don't add jurors. But by the same token, you find out a lot about the jury when you're in the process of selection, and there can be very strong-willed jurors on there. And once you've exhausted your challenges, your peremptory challenges, those jurors are on there, so as long as they've assured the court that they can be fair. And I can tell you that there have been a lot of interesting. When I was a trial judge, I had a jury. I had a litigation partner from Cravath, Swain and Moore as the foreman in one case. And one of my colleagues, Amalia Kieris, who's one of our law clerks here, was picked for a jury in New York State Court. So you do get, maybe I've just got a different view, because New York, everybody has opinions in New York. So we're used, even cab drivers do. So it may be different. It's worth thinking about, but so far it's not part of our system. Yeah.
Thank you. We've been talking about the Rehnquist Court's protection for structural protections in the Constitution, and I'm just curious about the panelists' views as to whether they see any inconsistency in the Chief's majority opinion in Dickerson versus his defense of federalism at the state-federal level. Because, as you know, Justice Scalia really took the Chief to task in Dickerson for sort of building on this Cooper versus Aaron holding that Marbury was all about judicial supremacy versus judicial review, and I'm curious as to whether you see, in terms of defense of structural protections, any inconsistencies in those threads of reasoning. And specifically, a different question to Professor Natapoff. I thought your argument about the metaphor of suspicion driving a lot of the Fourth Amendment jurisprudence was very persuasive, but I'm just wondering what sort of alternative approach to that jurisprudence you might offer.
As far as the first question is concerned, I'm going to turn to some of my academic colleagues for that one, because I haven't really thought. I mean, I don't feel that I could really make a great contribution on that particular point.
Richard, Alexandra, the first point. Do you want to?
Well, I'm not sure. I haven't looked at Dickerson in a while. I guess I personally don't see any incompatibility. I mean, we read the Constitution, various contexts to impose limitations on the states. To me, that doesn't in itself reflect a violation of federalism. I mean, there are going to be some limitations, and this is one where ultimately, for the reasons the judge said, he found there's a violation. So, I mean, do you think it reflects the Cooper's v. Aaron type of thinking? Yeah. Yeah.
Keeping the state power appropriate. But yet here you have sort of a horizontal separation of powers challenge.
Yeah.
And Scalia is saying, look, Cooper versus Aaron is simply wrong in sort of making the Supreme Court the supreme authority of constitutional law.
Yeah.
And here he's saying, Rehnquist, you're sort of overruling Congress on its reading of the Constitution, which is not dictated by the text of the Constitution.
Yeah, but I mean, as I understand the debate over Cooper v. Aaron, and I mean, I agree with the criticism that the Supreme Court at times has said, I think Scott Powell said it went from Marbury v. Madison saying we're in the game to the court ultimately saying we are the game, But Marbury also said, as I understand what Marbury is about, is we the court decide cases. And when they decide cases, they're entitled to have their view of the Constitution. So when they're in the context of the case, I don't think there's any incompatibility them saying we have a different view from Congress and we decide the case our way. That's the way it appears to me. I mean, I can appreciate why Scalia would want to lambast him there, but I think the defense is a different context. I think the Constitution provides this limitation.
Alexandra, what on the alternative? I mean, there's an interesting question. We've had these separate, interesting conversations about pragmatism versus principle across different areas in criminal justice. And Judge Walker's observation, which, by the way, is reflected at the time of the Rehnquist court in a fair amount of literature on how important criminal procedure was. But I wonder if there are, other than that very broad conversation about Justice Rehnquist's perhaps lean toward pragmatism here, a stronger lean in the area. I wonder if there's principles that connect across theirs. And I suppose, Alexandra, that this is a version of that. It may be an unfair restatement of the question, but in the Fourth Amendment area, it's sort of a compelling story, but and an interesting one, a provocative one that connects to now that you gave about those cases. What are the alternatives? In Wardlow, in Wren, or more broadly, you described suspicion as a line, a critical line, and yet I think an awful lot of folks would think about the Fourth Amendment as hardly a line, but somewhere between a process and a mess. And and then what implications? What insights does the Rehnquist court or Justice Rehnquist have? And I'd sum this up by a wonderful comment. A quarter of the JD students at the University of Arizona are from outside of the U.S., absolutely wonderful students. And there's a wonderful Chinese student who graduated last year, and at the end of the first year, he came into my office, and he said, Professor Miller, I've learned so much this year. It's wonderful. I've enjoyed my classes. And I think I understand something about American law, most of American law, at least for a first-year student, except for one thing. He said, one thing I will never understand. Never. I said, what? He said, the Fourth Amendment. And then he went on for 20 minutes of I don't understand the mess it creates. It's so contextual. Why are we trusting courts? This gives no guidance to police. How can a state run this way? A position he has not changed since, but yeah.
So to your question, the first, so what are our alternatives? Of course, the court used to run this on an alternative model, which was a preference for warrants. Right? So we could say that there would be more of a power sharing between police and the judiciary in ways that has been abandoned, but of course that's the classic alternative, right? Not to leave it to the instincts or the judgments of police on the street in the way that we currently do. I want to suggest too that a different way of handling it would be to handle these questions of inferences differently. And of course I take the point that that maybe the idea that suspicion is a line is a generous grant, but the court certainly treats it as an on-off switch. If you have suspicion, you can do X, Y, Z. If you don't have suspicion, you can't. Right? So the court certainly thinks of it as a dividing line between very important authority of the state and not. And that authority flows from evidence, but of course, there are better experts on evidence sitting at this table than I, but the inferences that we draw from evidence, the court could handle those differently. So let's just take Wardlow, for example. So that's the case that held that flight from the police in a high crime community generates an inference of criminality, thereby empowering the police to exercise their governance authority. So we could tell that story differently, as the dissent in that case did, because it turns out there are a lot of reasons that people run from the police in high crime communities from which we can draw no inference of criminality. Ironically, we can even draw an inference perhaps of poor police governance. So for example, I teach in Los Angeles, and the example I use for my students is if a person walking down, Rodeo Drive in Beverly Hills sees a police officer, looks startled, and runs, it's hard to think of another reason other than the fact that they've done something wrong that they might have done that. Whereas in South Central Los Angeles, there are very good reasons, and residents in neighborhoods like that tell us all the time that they have rational reasons to be afraid of what will happen if they do have an encounter with the police, regardless of their culpability. So a police officer who walks into an environment and sees people running could draw the inference that they're all criminals, or could draw the inference that he or she is doing a bad governance job. And so the court has institutionalized a certain version of those inferences, but the court didn't have to pick that one. So I think there are a lot of ways that we could craft the rules differently, and I want to suggest that second way is also a form of pragmatism. It's just pragmatism from the perspective of a different population. It's pragmatism not from the perspective necessarily of the governance structure, but from the people who are governed. And there's a rich literature challenging the empirical conclusions that are taken, as given, from which we draw the inferences about criminal procedure, and this is just one of them.
If I could just follow up on one comment you made about the warrant becoming less important. And I think that's true, but the reason for exceptions under the Fourth Amendment to the warrant requirement, so many exceptions that have been developed, is a function, I think, of the sort of the human aspect of judging. And the fact of the matter is, at the trial level, at the Court of Appeals level, and at the Supreme Court level, the court does not like to see guilty people go free. You just don't like to do it as a general rule. And if that's true because evidence has been excluded, then I think it's fair to say that the existence of the exclusionary rule has put hydraulic pressure on interpreting the Fourth Amendment in such a way that creates these loopholes. It's a less pure Fourth Amendment now as a result of the fact that evidence is excluded once the Fourth Amendment is deemed to be violated. Now, I don't know whether that counsels against getting rid of the exclusionary rule or somehow modifying it or figuring out another way to hold police accountable other than by excluding evidence. But if we hadn't had the exclusionary rule, I'm pretty sure that we wouldn't have the exceptions to the warrant requirement that we have today.
So there are a bunch of good questions, and let's take them, and then if as I doubt, questions peter out, we might return to that topic and think about the pragmatism that led to the federalization of the exclusionary rule in the first place. So, Michael, do you want to, there's Andy Chuck, the person, Joe, right there. Yeah.
Thanks. Just one further thought about Dickerson. I know we've talked about it a lot already, but I'd be curious. I absolutely agree with the point you made, Judge Walker, about the pragmatism reflected in the opinion. And of course, that's also reflected in the fact that so many police departments were actually on record in Dickerson supporting the court keeping Miranda in place, having learned to live with it. But I've always thought there's another side to it too. You know, the chief didn't have to choose to write the opinion. There were plenty of other people on the court who would have been delighted to write the opinion upholding Miranda. I think there was possibly a principled issue behind it as well, which is that the worst thing that could have happened, probably from the chief's point of view, would have been to have someone write the opinion in a manner that said, you know, as the Supreme Court, we can not only make rulings about the meaning of the Constitution, but we can also make rulings prophylactically to protect constitutional rights. That would have been, I think, something the chief would have been very much disturbed by. And he wrote the opinion kind of threading the needle without saying ever that the court has the power to make prophylactic rules. You know, he himself had called Miranda a prophylactic rule back in the day when he wanted to get rid of it, but now that it was time to keep it, that opinion was, I think, very carefully written so as never to say that, which left him open to the criticism of the Scalia dissent that the opinion was, for lack of a better word, incoherent. I think that was partly why he chose to write it. It's just my guess.
Any of the law clerks, chief's law clerks who are here want to talk about assigning opinions. I think you made a valid point, the way he assigned opinion to himself here, but also what would his thinking be in assigning opinions to others. And apart from the fact that he was fair, I think that there was also the aspect of wanting to make sure that the case still came out the way he wanted it to. And so the swing justice might get the nod in a particular case, but go ahead.
I think another factor, a simple factor, is that Chief Justice, going way back, have often assigned opinions to, let's say, the most surprising member of the majority. In other words, if it's a liberal opinion, assign it to a conservative, assign it to a liberal. It looks good, and it tends towards narrowness of opinion. So that may have been part of it, and he was certainly the most surprising member of that majority. Yeah.
Michael, you want?
And just a footnote of the comments and the points that were just made, it's also perhaps relevant that the chief's vote was not necessary to the outcome of that case. And I think I've got two questions. One, do you harbor any of you harbor any suspicions that the chief's vote might have been different if there had been 4 votes apart from him in dissent in Dickerson? And secondly, is there any possibility, you think, based upon your study of the chief's views on the Fourth Amendment and his views on the Fourth Amendment as an associate justice, that if the case had come up 4 years earlier when he was an associate justice, that his vote would have been the same? I mean, obviously, his vote in the case, I think, surprised a lot of people. Any comments on those points?
I mean, a lot of the reasons that he gave were reasons that, I mean, what you're really talking about here is the sort of the power sharing and kind of the nuts and bolts of getting 5 votes and so forth, as opposed to reasons. That gets into the question of subliminal thinking in making some of these judicial decisions. You know, why did Justice Roberts find the tax rationale in the Affordable Care Act case? You know, so That's for a different panel. At a different time. I don't have any particular insights there, but you've got a hunch and might as well go for it.
Michael, and Andy, and I think there are one or two other hands as well. But.
So this question is mostly for Alexandra, but I'd love to hear the thoughts of the other panelists as well. It seems to me that your talk was animated in large part by a concern about the cost of the that the criminal justice system imposes as it currently operates on members of a vulnerable population. And I'm wondering if it's possible to redraw the line, if you think it's possible to redraw the line that the Rehnquist court has drawn in this era and that we're still living with in many respects today, without reducing the benefits of the criminal justice system to a similarly vulnerable population, maybe even the same population in many cases. In many cases, it seems like the individuals who are bearing the costs of over or indiscriminate policing or racially biased policing or careless policing or the same individuals living in the communities with the biggest crime problems, which, at least ostensibly, these law enforcement practices are designed to reduce or counteract.
Just to be clear, I'm not sure I understand your question. Are you talking about the folks in those neighborhoods who are also entitled to full-fledged law enforcement protection and who suffer from under-enforcement?
Right. It seems like the clear animating concern that drove the Rehnquist court's decisions in this area, the Rehnquist court's decisions to permit police to stop citizens, to search citizens, to stop cars, sometimes without warrants, sometimes with lower standards of suspicion than had previously been allowed, was a concern to preserve the benefits of aggressive law enforcement to the citizens that aggressive law enforcement is designed to benefit. And although you seem to studiously avoid taking a position in your talk about where the court drew this line, my sense is from your comments and from sort of the undertones of your talk that you think this line has some problematic implications and results in some problematic burdens being placed on a vulnerable population. But of course, there's another side. I mean, there's a trade-off here. And if we redraw that line, we at least run the risk of reducing the benefits of law enforcement, benefits which we might at least think as an initial matter, as a superficial matter, are likely to run to the very same populations who are bearing the costs of the current system.
I now understand your question. So I'm going to answer your question, if I may, by reframing it a little bit. So in a piece I wrote a number of years ago called Under Enforcement, I thought about that precise dynamic. And I think that over enforcement, so let's label racial profiling, intrusive and aggressive policing of the kind that I think and many think overburdens certain vulnerable groups as over-enforcement. And let's label as under-enforcement that cost to communities that suffer from high crime rates, from the sense of vulnerability and lack of protection. And the assumption is that over-enforcement is the cure for under-enforcement. And I wouldn't suggest that that's not the case, that in fact, over and under-enforcement are flip sides of the same coin of a failure of governance. That what you see in communities that are vulnerable, that lack political clout to ensure robust, accountable policing is precisely what you see is both. And because they are both symptomatic of a mismatch between the needs of a community, its political and local desires, and its relationship with the state in the form of police. What you see in well-organized communities is plenty of the right kind of law enforcement. It's very rare to hear anyone in a low-income, high-crime community say they want less policing. In fact, they often ask for more policing, but of a different kind. And so I think we, it's a little bit of a definitional trap to think that more policing is the solution to under-enforcement, when in fact, the point I gestured to earlier, which is that what people really want is a better relationship with the police in their community, and that is a highly local matter. It is a matter that is currently being worked out in great messiness in different communities in different ways, and I think in many ways that criminal procedure is an awkward remedy for that fundamental accountability problem.
But you are talking about the way in which the law is enforced, aren't you? I mean, isn't that, I mean, over-enforcement is not just adding police, it's also how they do their job, right? And so if that, and that is largely a function of police procedures and how the courts react to those procedures. So that there is a regulation, if you will, of police behavior through the courts that exists. I don't think, I think that this is, we're not dealing with something that's static. Societies change, neighborhoods change. Something that wasn't necessary to achieve proper law enforcement in a particular neighborhood 1 year may change in 5 years. And so there's a constant calibration that's going on, and usually calibrations go on after, it's sort of like closing the barn door after the horse has left. I mean, you're reacting to what already happened. So this is a very difficult problem. It's not something that's easily resolved, I think.
Well,
if I could just, yeah. I hope that what I said didn't seem to be in any contradiction to that. I don't think, obviously I think the criminal procedure plays an immense role in the effort, of course, to regulate police, but also to regulate the way we think about the proper values that should go into the question.
Yeah, and it's that last point that I think is a very helpful one to end on, and I think it reflects all the conversations we have had here about the extent to which criminal procedure decisions by the Rehnquist Court or by Justice Rehnquist, or recent decisions, whether the doctrinal shifts are fundamental, maybe in the way Crawford was, right, a real vector, in the way some of the earlier discussions of the federalism decisions were, or instead have to do with messaging. If you're talking about 1 million plus felony charges a year and 15 million, some huge number of misdemeanors, these 31 tens of millions of interactions, street and otherwise, as pervasive as the criminal justice system is, an awful lot of what will govern police-citizen interactions are going to turn on other kinds of rules, norms. And how many people here think that it will be courts that are the primary engines, U.S. Supreme Court or otherwise, that will respond to the high-profile cases that are now being discussed, or the police practices? And it strikes me courts are not irrelevant to this, but they never have been. We're not during that period, and certainly are not now the prime drivers of the cultural or social changes for a system that involves these massive, ongoing, day-to-day, pervasive interactions, and that's worth thinking about, and perhaps distinguishing it, or perhaps not, from at least the earlier conversation on federalism. We have one more great conversation to come. It is time for a break. The last session on the First Amendment and religion, another great panel, will begin, and the moderator for that will be Dean Emerita Tony Massaro, who, as was noted earlier, was essential to the founding of the Rehnquist Center and to hosting Justice Rehnquist here. So we'll meet again in 15 minutes, and thank you.